no. So she was, I wonder if I can hear her, but she's so soft spoken. This one, I no problem hearing her at all. But I don't know why. Why didn't she just go like this? Because she was leaning.
Move the chair over as much as you can.
That's what she, and she
Was
needs
she
to.
there?
I don't know if she was this.
I thought she was writing right here. She had the notepad.
Yeah, I don't, and I know she was leaning over, so I think what she's doing is she's leaning over and listening, and then she's answering. And it's picking it up, but it's a little harder, you know, I have to go up and down with the volumes. So just, if she could just speak. I mean, it's not comfortable. Maybe if she did this, if she looked this way, because she was looking that way, if she sat like.
Looking to hear someone.
Yep, so.
Someone was questioning from here.
Mhm.
There's no.
So if she just sits like this and looks at the witness and does this, that would work.
Let's talk to her before.
Yeah, and Smith, I'm gonna have to put that microphone right in his face. And it's just a little harder when they walk away, you know, like, you know, because sometimes, because you've said something to them when they
Wait
walk.
till you get where you're going to ask.
Yeah, yeah. Oh my God. So. That's so cute.
Rachel's husband made the sheet.
Oh my God, how cute. He's handy, isn't he?
He is. And then my girlfriend made the hearts.
Oh my God, how cute. There's rolls of thread. Oh, God, people are so clever, aren't they?
I know. She's like
really
Pinterest.
Cute. You're kidding me.
She saw it on Pinterest.
Is she artsy anyway? Oh, I couldn't even think. Even if I saw a picture of it, I probably wouldn't be able to do that.
She made
That's really cute.
clothes for dolls, and she dressed $50 for me one year and donated them to a program that I'm associated with, to give out to the little kids. Yeah.
Oh,
I had no idea. She's crafty. She's crafty like that.
Oh, oh boy.
What?
I had just put
What?
lotion on.
Yeah,
Okay,
that's.
I'll clean it.
Are you kidding me? I tried to look like right here. Yeah, this is.
Yeah. How do I use this? All right, that'll work then.
Oh, 9 o'clock Raymond is the story.
Hey Royce, how's it going?
Good. How are you doing?
I'm good. I haven't seen you for a long time.
Yeah, I've been busy. I feel like every time I get a shift over there, I have to give it away because I have other
Yeah.
stuff popping up.
You have other life outside of the 34th District Court.
Unfortunately, I never did.
Hey, when have you spoken to the defendant, or do you need? Oh, I made you co-host, so you can.
Oh, okay. Are they over there in a breakout room somewhere?
No, not yet. No,
Okay.
they haven't arrived yet.
They should be joining shortly.
Cool.
This is 240091 FY, State of Michigan versus Darnay Ventus. May I have your appearances?
Good morning, Your Honor. Royce Nunley appearing on behalf of the defendant. We'd waive a formal reading and ask the court to enter a plea of not guilty.
Sir, state your name for me, please.
My name is Darnay Ventus.
Mr. Ventus, you had the opportunity to speak to Mr. Nunley this morning. You understand why we're here.
Yes, ma'am.
And you were able to hear him just now indicate that he's waiving your right to hear the reading of the formal charges against you and ask the court to enter a plea of not guilty on your behalf.
Yes, ma'am.
Sir, you have a right to be represented by an attorney in this matter. If you're unable to retain an attorney through your own resources or that of friends and family, the court is able to appoint one for you. Attached to your file is a request for an appointment of an attorney, and the court has signed that order. You'll be assigned an attorney going forward. It will not be Mr. Nunley. It will be another attorney that relies on the information contained on this form to be in contact and communication with you. Sir, you also have the right to be considered for pretrial release. The recommendation from Van Buren Township is that your bond be set at 5,010%. Mr. Nunley, what say you to that recommendation?
I disagree with the recommendation. I think that Mr. Ventus is a really good candidate for a personal bond. Unless I know something or unless I don't know something that you know, he indicated to me that he has never been in trouble. This is the first time that he's ever been in any sort of trouble. He works full-time for Priority Waste. I guess he drives a garbage truck, lives in Livonia with his family, not on probation or parole, no history of failure to appear. I believe that he's a good candidate for a personal bond. I don't know that he has any money with him with which he could pay a cash bond. So I'd ask the court to consider a personal bond for him.
Thank you, Mr. Nunley. The court will note for the record that the recommendation submitted to the court from Van Buren Township Department of Public Safety does not list a reason why Mr. Ventus should be placed on a cash bond. And Mr. Ventus, just so you understand, the default position is that everyone's entitled to personal bond unless there's some reason why they should not be. The criminal history in this file shows that this is the only offense that appears on your record. That, coupled with the fact that there is no explanation for the recommendation, means that the court will set your bond at 5,000 personal. You do not need to post any money, sir, but what you must do is continue to appear and participate in these proceedings until the case is resolved in its entirety. Sir, your next appearance date will be next Wednesday, February 21st at 9:30 a.m. with me on Zoom in courtroom number 1. Again, this is 240091 FY. Next appearance date, February 21st at 9:30 a.m. on Zoom with me, Judge Martin, in courtroom number 1. Anything else, Mr. Nunley?
Nothing further. Thank you, Judge.
Anything else, Van Buren?
No, thank you, Your Honor.
Thank you, Mr. Ventus. I'll see you next Wednesday. Have a good day, sir. Good luck to you.
Thank you.
Just 1 minute.
Morning, ma'am. Can you hear me? Ma'am, can you hear me? Miss Walrath, can you hear me? Ma'am, can you hear me now? Miss Walrath?
Yes, I'm here.
Okay, good. Thank you.
Can you hear me?
Yes, I can. Thank you.
Okay. You got your keys. Okay.
Good morning, sir. Can you hear me?
Yes, I can.
Hi, what is your name, please?
Brian Stein.
Brian. Oh, I see. Okay, you're at 10:15. Got it. Thank you.
Yep.
Brian Steins, correct?
Yes, please. Yes.
Thank you.
You're welcome.
Morning, Mr. Brown.
Good morning.
Do you need to speak with Miss Walrath? She's here, or are you ready for the judge?
Yeah, we could speak, and if you could just put
Yep.
Leah from Swan Creek as well.
But you know what? I just made you co-host, so you can do whatever you need to do,
Okay.
or I can put you in, whatever you want.
If you want to put me in, it could be simpler. Right? Oh,
Yep, you got it.
thanks.
Good morning, Mr. Morton. How are you?
Morning.
I have Miss Garcia here if you need to go in a breakout room with her. Oh, the judge is here.
Oh, the judge is here doesn't mean that Mr. Morton anyone else who needs to go into a breakout room can't go there. I'm just coming out so we can get going if there's something ready.
I believe Ms. Garcia is here present. Mr. Steins, I believe, is on one of my matters as well. And then I know I have a manager for Green Meadows, which I don't believe that tenant is present as well. I don't think Gist is present. So I will go speak to those parties, Your Honor, and I'll come back out.
Thank you. Mary Ann, is our next first date March 6th?
Yeah, let me check.
Thank you.
You are correct.
Good morning, Mr. Brown.
Good morning. Oh,
Oh, what?
Leah, it looks
What's
like
going on?
someone joined our waiting room, so we should go back over. I'll put you in there too.
Has you spoken with someone else? Or are you ready to go on Walworth?
Well, we spoke with someone, and it looks like the other defendant just joined the waiting room, so I'm gonna move back over there, then I'll be back. Thanks.
No. Ms. Walworth is back in the main session.
I'm back. I'm back now. I'm sorry.
You're fine.
It
Yeah,
took me,
No, no,
I
no.
believe
it took me a minute to figure it out how to get out of it on my phone. I'm sorry.
then
No,
that's okay.
don't be
No, then
sorry, ma'am.
Angel-
I just wanted to
Angel
make
Bur-
sure.
Yeah, and then Angel Brown looks like just joined the waiting room, so I'll go over there and take care of that really quick, and then I'll be right.
No. So we
Does that
can
work for
release Ms. Walworth. That's
Okay. Sure.
2400307 LT Swan Creek versus Carrie Walworth and Caitlin Zeck. Your names for the record, please.
Terry Walrath.
Good morning, Your Honor. Jeremy Brown for the plaintiff.
Mr.
We
Brown, we
did
were
have a
here on
chance to-
January 31st, and Ms. Walworth indicated she'd be filing for rental assistance. She filed the 539 with this court on the 1st. Ms. Walworth, what's the status
Yes.
of your application for rental assistance?
I did file for the SCR for DHS. The next day it was denied.
You
So
had a
I
chance to
did,
speak to Mr. Brown this morning? I'm sorry.
yes, I did. Yes, I
Did you
did.
reach some agreement, Mr. Brown?
Yeah, we went through, basically, we're just going to seek to enter the judgment. I guess it would be a consent for Miss Walrath, and then I guess it would be a default for her daughter Caitlin, but it would have the same effect. She's waiting for some tax money and some other payments that should come in around that same time, so hopefully it can be resolved, but we would move to enter the judgment.
The past due rent, sir?
The rent to retain is $2,910.17. The costs were $241.32 for a total of $3,151.49.
Mr. Brown, you said you guessed consent judgment. Was that the conversation agreement you had with Ms. Walworth?
Yeah.
Yes, Ms. Wallace.
Okay.
And Ms. Wallace, do I have your permission to sign on your behalf?
Yes, you do. You do.
Ms. Walworth, just so we're clear, you were here back on January 31st when there was a video played explaining your rights available this morning.
Yes.
And when you were served with the summons and complaint, you received a copy of that advice of rights.
Yes.
Do you have any questions about the rights available to you in these proceedings or the consent judgment that you agreed to with Mr. Brown?
No, I don't have any questions.
Ma'am, so your understanding of an agreement is that there is $2,910.17 in past due rent. Plaintiff is requesting cost of $241.32 for a total amount of $3,151.49.
Yes.
And you've just agreed to allow Mr. Brown's office to sign your name to that consent judgment submitted to the court.
Yes.
He will prepare the judgment with those terms submitted to the court. I will sign it and a copy will be mailed to you. Unless there's some other agreement, the judgment will indicate that you have 10 days to pay this amount or vacate the property, okay?
Okay.
Ms. Walworth, do you have any questions about this morning's proceedings or the consent judgment?
The only question is it says to vacate the property. Are they still saying that they have to do the writ, within the 10 days if it wasn't paid, or I can just be thrown out right then and there at the 10-day mark?
At the 10-day mark, if they wish to proceed, they have to come back to court and file another application file an application for a writ to have you removed. And what I
Okay.
typically advise tenants is if you reach some agreement with the management regarding payments, they'll relay that information to the attorney's office. Most attorneys just don't enter
Yeah.
the payment agreements during these proceedings.
Yeah. Okay. Yeah, because it's a waiting game for just waiting for my tax returns to come in. So, and that's what I'm basically waiting on to get all this taken care of, because we initially plan on moving anyways, but it's still waiting for all the money to come in.
The document that you receive will indicate as a consent asked to you and a default asked to the other defendant. But again, please be in contact with the management over at Swan Creek, okay?
I certainly will.
Thank you. You're free to go, ma'am. You have a good day.
All right. Thank you, guys. You
Thank
guys have a
you.
wonderful day.
Thank you, Ms. Barra.
This is 2400417 LT Rawsonville Woods versus Brian Steins. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Rossingville.
Brian Steins.
Thank you. The last time we were here, Mr. Steins, you indicated you'd be making an application for rental assistance. Did you do that?
No, I didn't, because I ended up going back to work, and now I'm waiting on my unemployment and everything. But me and the attorney had a talk already, and we've worked things out since then.
Thank you. Mr. Morton, what is that agreement?
Your Honor, the parties did speak, and we've entered into a proposed consent judgment. Rents retained are $2,836.69. Court costs of $190.24 for a total of $3,026.93 with a payment/writ date of February 26, 2024. I did advise Mr. Steins of his rights, specifically the fact that this would not be final for 3 business days because he's not represented by counsel. The fact that he did have the right to appeal this, and then additionally, he did give me permission to sign his name to the proposed consent judgment agreement.
Thank you. Mr. Steins, were you able to hear Mr. Morton just now?
Yes, ma'am.
And that past due rent of $2,836.69 is accurate?
Yes, it is.
And sir, you were here back on January 31st when the court played a video that explained the legal rights you have available in this landlord-tenant case.
Yes.
And you received a copy of the summons and complaint, which also contained a copy of that advice of rights form.
Yes.
Do you have any questions about today's proceedings or the consent judgment that you've agreed to?
No, Your Honor.
Then Mr. Morton's office will prepare that consent judgment, submit it to the court electronically. I will sign it and a copy will be mailed to you. Anything else in this matter, Mr. Morton?
No, Your Honor.
Anything else, Mr. Steins?
No, ma'am.
Thank you, sir. You're free to go. Good luck to you. I'm glad you're back to work, sir.
Yep, thank you.
This is 2400362 LT Rawsonville Woods versus Doran Garcia. Please state your names for the record.
For the record, Attorney Ian Morton of Palace Law on behalf of Rossingville.
Mr. Garcia?
I'm sorry, disconnected there.
You're okay. Today was the day and time scheduled for the second hearing in this matter. When we were here back on January 31st, you indicated on the record that you'd be applying for rental assistance. Did you do that? Did you speak to him, Mr. Morton?
Yes, I did, Your Honor. And
Okay.
I can re-put this on the record if once he connects more in full. But I can
Brown?
advise the court that the parties did speak. We did agree to enter into proposed consent judgment agreement. Rents retained were $2,495.98. Court costs of $190.24 for a total of $2,686.22. We did give a payment date of 2/26, but his intent is to be able to pay the funds within the next 4 business days. And I did advise him his rights, specifically of the 3-day time period, the 10-day time period, and the fact that he did give me permission to put his name on the proposed consent judgment. But if he logs back in, Your Honor, I'll be here for a little while longer as well, talk with some other parties. So if he logs back in, we can put it formally on the record with Mr. Garcia. But those were the terms that we discussed and he agreed to.
Mr. Garcia? Mr. Morton, I wrote the terms down. If he disconnects and reconnects, I will inquire of him, and if we need anything from you, I'll have Mary Ann move you back to the main session, okay?
Certainly, Your Honor. Thank you.
Thank you. This is 2400296 LT Swan Creek versus Angel Brown. Please turn your videos on, unmute yourself, state your name for the record.
Good morning, Your Honor. Jeremy Brown, on behalf of plaintiff.
Angel Brown.
Thank you. Today is the day and time scheduled for the second hearing in this matter. When you were here last, you indicated that you'd be filing an application for rental assistance. Did you do that?
Yes.
You're also advised that if you file such an application, you would need to file a form with the court called a DC 539. Did you do that?
Yes.
When did you do that, ma'am?
The day of my first court date.
There is nothing showing in the court's records that happened. Mr. Brown, you had the opportunity to speak to Ms. Brown. Were you able to reach an agreement in this matter?
No, we were just going to come back. So no payments have been made. We would move for the judgment, but I would leave it up to your call as far as the SER or the assistance. But we would move for the entry of the judgment.
Ms. Brown, the court does not show that you filed that form. I checked yesterday and I checked this morning less than an hour ago. There's nothing in the system that shows that you've complied with the court rule, ma'am.
It got emailed.
I understand that, ma'am, but the civil department checks the email regularly. And if you emailed it to them the last time we were here, which is on January 31st, it would have appeared in these last 2 weeks. That being the case, Mr. Brown, what is the rent to retain possession, please?
$3,007.26. Costs of $185.66. For a total of $3,192.92.
Thank you. Ms. Brown, were you able to hear Mr. Brown just now?
Yes.
Is the amount of rent claim due and owing correct?
Yes.
Ma'am, inasmuch as you admit that the amount of rent claim due and owing by the plaintiff is correct, there is not a tribal issue of fact, and plaintiff is entitled to entry of judgment after hearing as requested. Mr. Brown will submit a judgment to the court that shows that $3,007.26, $185.66, and costs for a total judgment of $3,192.92. The court will enter it. Ma'am, if you have proof that you filed the DC 539 within 5 days of our last hearing, the court will not sign that judgment. But I have checked since we've been on just now, and I do not see that form was filed. That is the only thing that would have stayed these proceedings. Anything else, Mr. Brown?
That's all, Your Honor.
I'm sorry, Ms. Brown?
How do you show the proof that you sent it to the court? If you
say you emailed it, you'll be able to show the traffic. You'll be able to show the email submission. I'm telling you that as we sit here right now, I am looking in the court's file and I do not see it submitted. I'm telling you that I looked at an electronic version of the court's document system before I came out at 10:03 and there was nothing in the file. I checked all of the 7 files that we had scheduled for this morning, personally checked them. Open each document, and there is not a 539. I have specific notes for that, for those documents.
Okay, can I get the email again? Cause the email that I had got, it could have been wrong. That's the only thing I can think about, cause I sent it.
Put the civil department's email address in the chat, ma'am, but that document had to be filed within 5 days of our appearance. And that's something that I place on the record with each of the files so that we do not have this issue. Give me one moment, please.
Okay.
Oh, Ms. Brown, you said you emailed it. What email address did you use?
ab.brown2174.
No. What email did you use to send it to the court?
ab.brown21704@gmail.com.
Ma'am, what address did you use for the court? Not what address you sent it from. What address did you use for the court?
Are you talking about my home address?
No, ma'am. You said that you sent it to the court your last here on the 31st. My question to you is, what address did you use to contact this court civil department?
Are you saying like the email address?
Yes, ma'am. You said you submitted it by email.
Yeah, ab.brown21704@gmail.com is what I sent it under.
Ma'am, then the court will deem, the court will await receipt of the judgment from Mr. Brown's office regarding this matter.
Okay.
You're free to go. You have a good day. Mr. Garcia.
Thank you, Your Honor.
Mr. Garcia,
Good morning. Sorry, I had some
good
technical.
morning.
My apology.
No, don't apologize, but maybe if you turn your video off, it will help a little bit.
A little better?
I'm not sure. If you talk for a little bit longer, we'll see.
How about now? I'm just
Oh,
just trying to
wonderful.
test a few things.
Wonderful.
Hello. Okay.
Mr. Garcia, Mr. Morton was here previously and indicated that you reached a consent judgment with him that there's $2,495.98 in rent due. There's $190.24 in cost for a total of $2,686.22. Is that correct?
Correct, Your Honor.
Mr. Garcia, when you were last here, you indicated that you'd be filing an application for rental assistance. Did you do that, sir?
I did not, just under the circumstances of my conditions, I would not be approved. I'm not disabled or anything. I just, I make a decent amount of money. It was just a bad start of the new year. Child custody, attorney fees, on top of car rent, car repairs. It's a new year, little setback. I had to do a few things like, liquidate my 401k just to get on,
I understand, Mr. Garcia. I appreciate that. But you agree with Mr. Morton that a consent judgment will enter with the terms just placed on the record?
Yes, Your Honor.
And were you here back on January 31st and saw a video regarding the legal rights you have available in this landlord-tenant case?
Correct.
And sir, when you were served with the summons and complaint, you would have received a written copy of those rights.
Correct.
Did you have any question at all about the rights available to you this morning or the proceedings?
No, Your Honor.
Do you have any questions at all about the consent judgment that will enter in this case?
I do not.
Then Mr. Morton's office will prepare a consent judgment with the terms placed on the record. I will sign it and a copy will be mailed to you at the address we have on record. If there's nothing else, sir, you're free to go. You have a good day.
Thank you. You as well.
Thank you. Good morning, Ms. Methner.
Good morning. I'm
What are
appearing
you
on
here for?
so I'm appearing for Wendy Cooper on Nina Nicolaide's case. But we're just withdrawing the motion that we had. A notice was filed this morning.
What notice?
A notice of withdrawal.
Okay. Have you had the opportunity to speak to Mr. Morton?
We briefly, I know he was CC'd on the email, but we confirmed with his office that, with Pallett's office, that the judgment was satisfied, and so we're just withdrawing our motion to set aside the judgment.
Oh,
Yeah.
that works for me. I'll make a note in the file and I'll note the register of actions in 2303647 LT Holiday West versus Nicolaides that the motion to set aside is withdrawn and the judgment is satisfied. Was there anything else, Ms. Messner?
Nope, that's all. Thank you.
Thank you. Ms. Nicolaides, you may leave this court session. Good luck to you, ma'am. You have a good day.
Thank you, you too, Your Honor.
Thank you. Good morning, ma'am. I hate to bother you, but I'm looking for a DC 539 that might have been sent to your email. She said she filed it, sent it on January 31st. I can't imagine that you would have something unprocessed from there, that date. 2400296 LT. Angel Brown, she says that she's going to share her screen. It shows that she emailed it. I didn't, 2 weeks ago. It's signed in as complete. With some. Would that have been rejected so that she knew that? Okay. You can just add it to, just add it. Oh, no, there's nothing to do. Just note the file, I guess. Just note the ROA. Thank you. Bye-bye. Ms. Brown?
Yes.
I just talked to the civil department. I want to offer my apologies to you. They have your DC 539. The issue is it was not processed and it was not added to the file because you did not attach proof of what it was that you filed with DHS for the SCR money.
Okay, that's my apologies as well. When I had spoke to I'm not sure who he was, but when I spoke to the man, um, when it was explained to me, he was just basically stating that paper that I needed to file with you guys. So I had no awareness of the proof with DHS or anything of that sort. This is my first time going through something like this, so I'm a little bit confused on the process and everything. And it was just really an honest misunderstanding. But I just wanted to. I'm
Ms.
sorry.
Brown, I'm only cutting you off because you're doing exactly what you're supposed to do. You advocated for yourself. This is a new process. We're all working through it together. What is the status of your application for assistance, ma'am?
It was denied the first time, but my caseworker told me that it was denied because I didn't show my proof of income. I had to upload my daughter's SSI, so now it's currently in the pending process once again under review. She said that she'll be getting back with me sometime later this week. If not this week, then early next week.
Then Ms. Brown, what we'll do is we will need to adjourn this matter. You have the right to be protected by the state, but I need you to do something. You need to send to the court proof of that application. Your 539 is sitting in the email of the civil department. I called them when I saw you logging back on to check on it, and we do have it. We just need proof that you have actually applied for that assistance. Your adjourn date will be March the 6th. I believe it will be at 1 p.m., but court staff will mail notice to you at the address we have on record. Mr. Brown has left this court session, but I will make sure that we reach out to him and advise him that the judgment will not enter, that we are adjourning this matter due to the stay for the processing of your application for rental assistance, okay?
Okay, no problem. And just to confirm, what exactly do you need for me to confirm the application with DHS?
Do you have an email or a print screen that you can send to the court civil department that shows that you have at least made the application?
Yes.
Okay, then that's sufficient.
Okay, and you would like for me to email it to the same email I used prior before?
Yes, ma'am, and we're looking for it now, and I'll follow up with the civil department regarding your regarding the status of that matter, of that application and the attachment.
Okay, sounds good. Thank you.
Thank you for your patience and persistence, ma'am. You have a good day.
You as well.
Thank you. This is 2400358LT. This is Rawsonville Woods versus Nikki Ellington and Savannah Ellington.
For the record, Your Honor, Attorney Ian Morton of Palace Law on behalf of Rawsonville.
Ma'am, would you state your name for me, please?
I'm sorry, Nikki Ellington.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. The last time we were here, we adjourned so that payment could be made. The parties have spoken. Mr. Morton, how are we proceeding?
Your Honor, the parties did speak. So there, clarification to begin with. Miss Savannah Ellington, I've been advised, is an active duty military, but she does not live there, and that is also not her primary residence. So based off of Miss Ellington's statements, Miss Nikki Ellington's statements, we were going to dismiss her from this case to avoid any of those additional complications. But again, and I'll have Miss Nikki Ellington can confirm it once I finish speaking. But the statements are that Savannah Ellington is on active duty, but she does not live there, and this is not her primary residence. So if the worst case scenario happened, this still would not affect that as a residence for Savannah Ellington. Second, I did speak to Nikki Ellington. She did advise me that we both agreed to rents retained at this time, Your Honor, were $2,650.56. Court costs of $248.83 for a total of $2,899.39 with a payment date of February 23rd, 2024. She did advise me that there is an intent maybe potentially after this hearing to be able to seek assistance, but that has not been processed. So I advised her to do that immediately. And I did advise of her rights, which includes the fact that she has the right to be able to set this aside or make a request to set it aside within the next 3 business days. Further, the right to appeal, and she did give me permission to put her name on the proposed consent judgment agreement, Your Honor.
Oh, Mr. Morton, then I misunderstood. I thought you said you were dismissing Nikki Ellington.
No, we're dismissing Miss Savannah Ellington. I apologize if I confused you, Your Honor.
No, my notes were that Savannah Ellington was on active duty in a way. So, Ms. Ellington, when you appeared back on January 31st, did you have the opportunity to view the video that explained the legal rights you have available in this landlord-tenant matter?
I did. I heard it.
And ma'am, when you were served with the summons and complaint, you received a written copy of those rights as well.
With my paperwork?
Yes, ma'am.
Yes.
And ma'am, you had the opportunity to speak to Mr. Morton and you wish to agree to the consent judgment that he just placed on the record.
Yes.
Do you have any questions about that consent judgment?
No.
Do you have any question about this morning's proceedings?
No.
Then ma'am, the court will enter the consent judgment that Mr. Morton presents that shows that there's $2,650.56 in rent to retain possession, $298 in costs for a total judgment of $2,899.39. The judgment will indicate that you will pay this amount or vacate the property by February 23rd. No, that is a four. Was there anything else, Mr. Morton?
No, Your Honor, we'll submit the consent judgment and the dismissal to the court.
Anything else, Ms. Ellington?
No.
Thank you. That concludes this matter, ma'am. You're free to go. You have a good day.
You too.
Thank you. Mr. Morton, while you were away, Ms. Methrin advised that the 10:30 motion had been withdrawn.
Yes, Your Honor. That's from my
Thank
understanding
you.
as well.
Are we ready with Ms. Walker?
Yes, we are, Your Honor.
This is 2400422 LT, Rawsonville Woods versus Destiny Walker. Ma'am, please state your name for the record.
Destiny Walker.
Ms. Walker, when we were here back on January 31st, you indicated that you'd be filing an application for rental assistance. Did you do that?
Yes, I did.
Did you file the document called the 539 with the DC 539 with the court?
Yes, I did. I actually messed up the first time. I sent an empty one in, but then I got an email and she told me to fix it. So then I resent it in.
And what's the status of your application for assistance?
Still haven't heard anything back. No one has called me. I haven't got a notification or anything, but I told Rawsonville Woods I'm just going to pay it all myself out of pocket by the 22nd.
You had the opportunity to speak to Mr. Morton this morning?
Yes.
Mr. Morton, how are we proceeding?
Your Honor, I did speak to Ms. Walker. She did advise me of the fact that she was in the process of obtaining the assistance, but she's made the decision to be able to pay it on her own. As I told her, I understand that, but it's entirely up to her and how she wants to proceed in that fashion. However, based on that, Your Honor, we did come to an agreement on proposed consent judgment. Rents retained were $2,728.76. Court costs of $190.24. We're told $2,919.00 with a payment date of February 23rd, 2024. I did advise of her rights, specifically the fact that this would not be final for 3 business days. The fact that she does have 10 days to appeal this decision, and she did give me permission to sign her name to the proposed consent judgment agreement.
Ms. Walker, were you able to hear Mr. Morton just now?
Yep, I heard him.
And everything he said was correct?
Yes, ma'am.
And ma'am, when you were here back on January 31st, you viewed the video that explained the legal rights you had available to you this morning.
Yes.
And when you were served with the summons and complaint in this matter, you received a written copy of those rights.
Yes.
Do you have any questions about the legal rights available to you in this matter?
No, ma'am.
Do you have any question about the consent judgment that the court will enter with the terms that Mr. Morton just placed on the record?
No, ma'am.
Then Mr. Morton's office will prepare a consent judgment that shows that there's $2,728.76 in rent due and owing to retain possession, $190.24 in court costs for a total judgment of $2,919 with a further indication that you will pay this amount or vacate the property by February 23rd. Is there anything else, Mr. Morton?
No, Your Honor.
Anything else, Ms. Walker?
No, ma'am.
Thank you. Good luck to you, Ms. Walker. You have a good day. You're free to go.
Thank you. You as well.
Thank you. And when you're ready with gifts, Mr. Morton?
I will. They were in a vehicle that was moving, so I advised them that we'd take a moment, then I'd speak to them.
I appreciate that. There's an arraignment that's coming in. If we can get it done before the arraignment, that'd be great.
Absolutely, Your Honor.
Thank you.
Oh, Ms. Jess, we're just gonna have the judge walk back out. Was it, like I said, I was trying to move it pretty quickly, but it looks like she might have stepped off for a brief moment.
Okay.
Give me one moment.
Mr. Morton, I just went to get ink. I'm ready if you're ready.
I understand.
I'm
Yes, Your Honor,
ready.
ready to go. So for the record, sorry, Your Honor. Go
You're
ahead.
fine, ma'am. This is 2400337 LT Green Meadows versus Gist. Your appearances.
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Green Meadows.
Yeah.
State your name for me, please.
Nikki Langiff.
Thank you, ma'am. Today was the day and time scheduled for the adjourned hearing in this matter. Ma'am, when you were here back on January 31st, you indicated that you'd be making an application for rental assistance. Did you do that?
No.
Did you have a chance to speak to Mr. Morton just this morning?
Yes, I did.
Did you reach an agreement with him?
Yes, I did.
Mr. Morton, that agreement, please. Your Honor, a proposed consent judgment was agreed to. Rents retained are $3,181.69. Court costs of $190.24 of the total is $3,371.93. As an advisor, that includes the month of February as well. I did advise her the fact that this would not be final for 3 business days, the fact that she has the 10 days to appeal the court's decision, and she did give me permission to sign her name to the proposed consent judgment agreement with the 2/23 date, Your Honor.
Thank you. Ms. Gist, when you were here back on January 31st, you saw a video that explained the legal rights you had available this morning?
Yes, ma'am.
And ma'am, when you were served with the summons and complaint, you received a written copy of those rights.
Right.
And after having a chance to speak to Mr. Morton, you wish to enter a consent judgment with the terms he just placed on the record.
Right. Correct.
Ma'am, do you have any question about the rights available to you this morning or the consent judgment that the court will enter?
No, I did not.
Do you have any questions at all regarding this morning's proceedings?
No, I did not.
Then Mr. Morton's office will present the consent judgment with the terms he just placed on the record. The court will sign it, and a copy will be mailed to you at the address we have on file. Mr. Morton, is there anything else in this matter this morning?
Nothing else, Your Honor.
Anything else, Ms. Gist?
No, thank you for being so patient with me.
Absolutely, no worry. Oh, I forgot you were driving before. Look at you, still at work.
I
No,
gotta
Ms.
get
Gist.
this money.
No, listen, it's fine. You go make that money. You drive careful. I see the snow has started. You have a good day.
Yeah. Okay, thank you.
Thank you.
Bye-bye.
Mr. Morton, I believe that concludes your docket this morning.
I believe it does. Everybody appeared or the matters were removed. So all set. I'll submit those proposed judgments to the court today, Your Honor.
Thank you, sir. Have a good one.
Thank you.
This is 240092FY. This is State of Michigan versus Bassam Alward. Sir, state your name for me, please.
Bassam Alward.
Ms. Alward, there is a note in the file that you wish to waive your right to have the assistance of the court-appointed attorney this morning. Is that correct?
Oh, yeah.
Sir, it's alleged that on February 12, 2024 in Huron Township, you committed the following. Count 1, police officer assaulting, resisting or obstructing, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Michael Kaze, a police officer, Huron Township Police Department that you knew or had reason to know was performing his duties. That's a felony, punishable up to 2 years in prison and or $2,000 fine. Count 2, police officer assaulting, resisting, obstructing, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Joshua Preeb, a police officer with Huron Township Police Department that you knew or had reason to know was performing his duties. That's, again, a felony, punishable up to 2 years in prison or fines of up to $2,000 plus court costs. Count 3, assault or assault and battery, that you did make an assault or an assault and battery upon the following person: Trevor Morgan Guile, contrary to MCL 750.81 sub 1. This is a misdemeanor punishable by up to 93 days in jail and or fines of $500 plus court costs. Mr. Alward, I failed to mention that the MCL for the first 2 counts was MCL 750.81D sub 6. Sir, inasmuch as you are unrepresented by an attorney this morning, the court will have you stand mute to the charges against you. You have a right to be represented by an attorney in these matters going forward, inasmuch as this is a felony case.
There is an application for court-appointed attorney attached to the front of the file. The court will sign that. You will be assigned an attorney going forward. That attorney will rely on the information contained on the form to be in contact and communication with you. Sir, you also have the right to be considered for pretrial release. The bond recommendation received from Huron Township does not list any recommendation, does not indicate whether or not they oppose personal bond or are requesting cash bond. It indicates that there is a felony and misdemeanor. The seriousness of the felony charges against you. Huron Township, do you have any information regarding the recommendation for bond?
Yes, ma'am. We're gonna ask for a cash bond in lieu of his appearance at court, 10,000, 10%.
Mr. Alward, do you have any comment regarding bond in this matter?
No, I just wanted to say, I never, assaulted anybody. It was out of self-defense. I went to go see my buddy.
Mr.
Ray.
Alward, I'm gonna ask you not to talk about what happened on,
Oh,
yesterday, the 12th. Today is just about getting you arraigned and getting you scheduled to return to court. The police department has indicated they're asking for 10,000, 10%, which will require you to post $1,000 to be released this morning. Do you have the capacity to post bond, sir?
Well, do I have to do what? To pay $1,000?
Do you have the ability to post the $1,000, sir?
Not right now. I would be able to, like, I have to work to get it. I still have to pay rent. I have DTE coming up. I have 4 daughters to take care of. I have 2 cats and three kittens at home. I got a lot of responsibilities.
Mr. Alward, the court will note that there is a brief criminal history that gives the court some concerns. The court will not set it at 10,000, 10%, but the court will set your bond at 5,000, 10%, which means that you need to post $500, sir, to be released. The court has concerns, again, because of the allegations contained in the complaint, specifically that there was engagement with law enforcement. And sir, your next court date will be next Wednesday, February the 21st at 8:30 a.m. That's back with me, Judge Martin, in courtroom number 1. Huron Township will give you a copy of that notice to appear. Again, this is 240092FY. Next appearance date is February 21st at 8:30 a.m. Anything else, Mr. Alward?
No.
Anything else, Huron?
No, ma'am.
Thank you. That concludes this matter. Good luck to you, sir. I'll see you next Wednesday.
Thank you.